Good afternoon, everybody. While everybody takes their seats very quickly, for those of you who didn't hear before, my name is Leah Willis. I'm the editor-in-chief of the Law Review, and it's my honor to have you all attending here with us at the 2024 Law Review Symposium. This is our first panel of the day. We're going to have a great debate, but just a quick announcement before we get started. There is a QR code that was outside the doors. It will be passed around on clipboards. That's how you can ask questions of our speakers. There will be some time for questions in this panel, and we would love to hear whatever you guys have got. And for our students out there, this is how you sign up to get your extra credit. Please note that you have to sign up each time that you come into the room and that we can see the timestamps, so please don't sign up for a session that you haven't actually attended yet. So with that, I'm going to turn things over to Josh, our symposium editor.
Thank you, Leah. So we've titled this first panel of the day, "The Debate is Not Over. Does the 14th Amendment Extend to the Unborn?" And the title of the panel reflects the fact that there are some pro-life advocates that have considered the question whether the 14th Amendment's promise of equal protection should extend not only to the already born, but also to the preborn. And we have on this panel two people that have both addressed that, but reached opposite conclusions as to what the proper answer is. So we're excited to hear from them, and we're also grateful to have Olivia Summers with the ACLJ here facilitating that panel. So I'll introduce Olivia and then turn it over to her. Olivia Summers is Senior Litigation Counsel with the ACLJ, focusing on pro-life advocacy and protecting the freedoms of speech and religion. She earned her JD from Regent University School of Law. While at Regent, she clerked for the ACLJ and served as a board member for Regent Journal of International Law, was a member of the Honor Council, and was actively involved in Regent Students for Life. In addition, she spent one summer interning at the ECLJ, where she gained experience in international law and human rights issues. Prior to attending Regent, she earned her BA in history from the University of Wyoming. In addition to her work at the ACLJ, Olivia served as a co-facilitator for a post-abortion healing group for women sponsored by a pregnancy resource center in Washington, D.C. She also currently sits on the board of Infinite Worth, a pro-life organization that works to provide 24-hour nurse chat lines to pregnancy resource centers around the country. Please join me in welcoming all three of our panelists.
Thank you, Josh, and thank you all for joining us here for Regent Law Review's first panel discussion, as Josh said, entitled, "The Debate is Not Over. Does the 14th Amendment Extend to the Unborn?" On June 24th, 2022, the pro-life community received news that many of us did not think we would hear in our lifetime. That through Dobbs v. Jackson Women's Health Organization, the U.S. Supreme Court had overturned its Roe v. Wade decision. When the news broke, I was in my car in Missouri, driving to the airport. I was all by myself, so it was a little bit of a letdown. But my phone started getting text after text from the pro-life community, texting me to say, "Congratulations, we did it," and otherwise celebrate in this momentous achievement. It was a very emotional moment. It still is. And it was truly an accomplishment and a very important step. But the Dobbs decision, to quote Churchill, is not the end. It is not even the beginning of the end, but it is perhaps the end of the beginning. The fight for life is far from over. In the first calendar year after Roe fell, abortions increased in the United States. There were an estimated 1,037,000 abortions that occurred in the formal healthcare setting. That means that many other abortions via the abortion pill or other methods were not counted, and the number is likely much larger. This was the highest number of reported abortions in the United States in the last decade. For those of you who were here earlier today, you heard an in-depth history of abortion and the pro-life movement. As a quick recap, Roe v. Wade was the U.S. Supreme Court decision to legalize abortion across the United States, in all 50 states. Now, there's a lot of misinformation out there about what Roe did and didn't do. What it did do was force states to make abortion legal. What it did not do was restrict abortion at all. What it did do was allow states to regulate abortion at some levels, but only after a baby was considered viable, which is roughly at 6 months of pregnancy, so late term. Thus, under Roe, all states were prevented from regulating abortion prior to viability, and no state was required to prevent late-term abortions. Now that Roe has been overturned, every state is generally free to regulate abortion as it sees fit. At least 14 states have banned abortion with limited exceptions, but some states have allowed abortion through birth, and some have even removed protections that were in place to protect babies born alive after botched abortions. It is clear that more needs to be done across the country to protect preborn children from abortion. As indicated by its title, this panel is about to discuss whether the 14th Amendment's Equal Protection Clause does or should extend to preborn children as a means for further restricting abortion in the United States. Now, there are two things that tend to happen when abortion is discussed. It either becomes an entirely emotional conversation and logic and reason are kind of thrown out the door, or it's a scholarly and hypothetical debate that's lacking some emotion and is hypothetical in the sense that it seems to oversimplify the answer to the problem that is abortion. Today, we're having a scholarly discussion. So during this discussion, I want you to keep in mind some of the faces of those who are affected and hurt by abortion. I want you to think of the surrogate mother who is 23 weeks pregnant and being forced to get an abortion by a couple who no longer wants the baby. I want you to think of the woman who took the abortion pill at 15 weeks and delivered her dead baby into the toilet and now doesn't know what to do with his remains because she doesn't want to flush him down the toilet like she was told to by Planned Parenthood. I want you to think of the woman who delivered her baby alive at 32 weeks in a toilet in the ER because she was visiting, because she had complications from the abortion pill. I want you to think of the teenage boy who got his girlfriend pregnant and now she's getting an abortion against his will, even though he and his family want the baby and would do anything that they can to support her and the baby. I want you to think of the 14-year-old girl who is being forced against her will by her mother to get an abortion. These aren't hypothetical cases. These are cases I know of personally. These are real people around whom the pro-life community has rallied, whom we have aided, and they are the reason we are here today. In fact, the case of the 14-year-old girl is one I learned about just 2 days ago. Because of the pro-life community and the support that she and her mother received and the information, the mother's heart was changed and she is no longer attempting to force her to get an abortion. These women, men, and their babies need a world where abortion is unthinkable and help is readily accessible. These people are why we're here today, to discuss solutions to the horror that is abortion. With all this in mind, I would like to introduce and welcome our panel speakers, Mr. Josh Craddock and Mr. Ed Whelan. Mr. Craddock is an affiliated scholar with the James Wilson Institute. As a practicing lawyer, he successfully petitioned the Supreme Court of the United States for certiorari and prevailed in Vega v. Hawk. I don't actually know how to say that. Teco, that's appropriate. And he represented a major technology clients in groundbreaking Section 230 litigation. That was a tongue twister, even though I practiced it. He's a graduate of the Harvard Law School, where he served as editor-in-chief of the Harvard Journal of Law and Public Policy. He then clerked for the Honorable Chief Judge Timothy Timkovich of the U.S. Court of Appeals for the 10th Circuit. Prior to law school, Mr. Craddock managed advocacy teams for several nonprofit organizations at the United Nations. His writing has appeared in the Notre Dame Law Review, Harvard Journal on Legislation, Washington Post, Newsweek, and National Review. Please welcome Mr. Craddock. Our second panelist is Mr. Ed Whelan. He is a distinguished senior fellow of the Ethics and Public Policy Center, EPPC, and holds EPPC's Antonin Scalia Chair in Constitutional Studies. He is the longest-serving president in EPPC's history, having held that position from March 2004 through January 2021. As a contributor to National Review Online's Bench Memos blog, he has been a leading commentator on nominations to the U.S. Supreme Court and the lower courts and on issues of constitutional law. He has written essays and op-eds for leading newspapers, including the Wall Street Journal, the New York Times, and the Washington Post, opinion journals, and academic symposia and law reviews. A former law clerk to Justice Antonin Scalia, he is the co-editor of 3 volumes of Justice Scalia's work, Scalia Speaks, On Faith, and The Essential Scalia. Welcome, Mr. Ed Whelan. All right, we're going to begin today with Mr. Craddock. He's going to state his position. You have about 20 minutes. And then we will transition to Mr. Whelan, who also has 20 minutes. And then we are going to have, as was stated earlier, question and answer period. So during the discussion, audience, put on your critical thinking caps and send us any questions that you have. Thank you. Mr. Craddock, the floor is yours.
Thanks so much. Yeah, hello, testing. I want to thank Olivia for humanizing this discussion, and I also want to thank Regent Law's Law Review for inviting us here for this important discussion. I also want to thank my counterpart, Mr. Ed Whelan, for agreeing to respond. We disagree about some legal things, but ultimately we're both here in the same fight, and we agree on many substantive issues. So this will be a good, friendly discussion. You know, a century and a half ago, we fought a civil war, and we amended the Constitution to ensure that every human being could enjoy equal protection of the laws. Today, some states deny that protection to children in the womb through legalized abortion. But as we know, from the moment of fertilization, those victims of abortion are fully human, and in our legal tradition, every human being is a legal person. And the Constitution says that no state may deprive any person of the equal protection of the laws. So that's why I stand resolved that the pro-life movement and lawyers should pursue a 14th Amendment strategy to ensure recognition of unborn children as constitutional persons entitled to due process and the equal protection of the laws. Now, like overturning Roe, securing these protections is going to be a long journey. It's going to be a process. But I believe that our existing Constitution is up to that task. Regrettably, I think some critics disagree not only with the prudence of this approach, but also with its soundness. They believe that unborn children are the only class of human beings whose natural and legal rights the Constitution fails to equally protect. Now, this position is often framed as the sober-minded perspective, but I think that denying personhood at this crucial moment in our constitutional history is neither legally sound nor politically prudent. So to understand why constitutional personhood is the next logical step after Dobbs, first we have to carefully read the Dobbs decision. As we'll see, that decision is consistent with and even favorable toward future recognition, securing equal protection of the laws to unborn children. Nothing in Dobbs forecloses that result, and neither does anything in the decision prohibit states or the co-equal federal branches from recognizing the same. Second, we'll revisit the historical evidence that unborn children are persons within the original public meaning of the Equal Protection Clause. And finally, we'll consider the practical and political implications of acknowledging that obvious truth. So to start, what did Dobbs say? Now, to properly interpret Dobbs, we first have to distinguish the majority's holding, right, the legal rule that resolves the case, from its dicta, right, the tangents, the asides, the commentary that wasn't strictly necessary to deciding the question presented. The only issue squarely before the court was whether the Constitution prohibits states from regulating pre-viability abortions. And the court's answer was simple: no, because the Constitution does not confer a right to abortion. Now, the court didn't need to decide whether unborn children are constitutional persons to answer that question, and neither party to the case pressed that issue to the court. So it'd be extraordinary then if the court had nonetheless decided it. As Chief Justice Roberts wrote in his separate opinion, courts follow a fundamental principle of judicial restraint by declining to formulate a rule of constitutional law broader than is required by the precise facts to which it is applied. So by reserving any decision on personhood for the future, the court necessarily, by implication, quote, returned the issue of abortion to the people's elected representatives. But that is the practical implication of the court's ruling, and it should not be confused with the statement of legal principle. It does not mean that the majority adopted Justice Kavanaugh's position in concurrence that the Constitution is neutral with respect to abortion. Indeed, the majority emphasized that its opinion, quote, is not based on any view about if and when prenatal life is entitled to any of the rights enjoyed after birth, including Justice Kavanaugh's view. Now, despite some overbroad dicta, I think that the logic of Dobbs militates toward future recognition of personhood. No fewer than 5 times the majority opinion observed that abortion is, quote, critically different from any other right that the court has held to fall within the 14th Amendment's protection of liberty, because it destroys what Roe and Casey called fetal life and what the law now before us describes as an unborn human being. 5 times they made that point. The majority repeatedly stressed this point as, quote, the critical moral question posed by abortion. In fact, the court even cited historical evidence that, quote, an infant in vitro se mère, right, French for in the womb, is regarded as a person in being. So at the heart of Dobbs, then, is the unavoidable fact that abortion takes a human life. And if that is true, if abortion takes a human life, then the question necessarily arises whether that living human being is, like every other human being, a natural and constitutional person, entitled to the same protection as born persons. So far from precluding prenatal personhood, Dobbs takes strides toward its future recognition. The Supreme Court has no holding now concerning an unborn child's constitutional personhood. And it would be entirely consistent with Dobbs and the principles of stare decisis for congressional legislation, a presidential executive order, or even a future Supreme Court majority opinion to recognize unborn children as constitutional persons within the meaning of the Equal Protection Clause. So what is the evidence that unborn children were considered persons at the time of the 14th Amendment's adoption? Well, the historical evidence is now overwhelming that when the 14th Amendment was ratified in 1868, the word person had a settled public meaning that included every living human being, including children in the womb. The Constitution itself does not define the term person, so we look to indicators of original meaning, such as dictionaries and treatises, common and statutory law, and the drafter's original expected applications to determine what that term means. So first, let's look at some definitions and treatises. According to dictionaries of common and legal usage at the time of the amendment's adoption, the term person was largely interchangeable with human being. So you could look to the 1864 edition of Noah Webster's American Dictionary of the English Language, in which he defined person as, quote, relating especially to a living human being, a man, woman, or child, an individual of the human race. Now, in legal usage, every human being was considered a person, and specifically a natural person. The authoritative treatise writer William Blackstone, right, who wrote the commentaries on the laws of England, you guys know him because pretty much every founder would have had a copy of the Bible, Shakespeare, and if they were a lawyer, a copy of Blackstone's commentaries. And what a lot of people don't know is that Blackstone actually begins his commentaries with a section on the rights of persons. And if you can believe it, he begins his discussion of the rights of persons with a discussion of the unborn child's right to life and personal security. So as Blackstone writes, he says that, quote, life is a right inherent by nature in every individual. For Blackstone, if human life existed, legal personhood existed also. There wasn't a distinction between biological human life and legal personhood. So the 14th Amendment, similar to the Civil Rights Act of 1866 that it was meant to support, codified equal protection of the fundamental rights of persons as those had been expounded by Blackstone and other legal treatise writers. So second, state practice, right? What was the common law and statutory practice of the states leading up to 1868? Well, centuries of common law legal practice consistently treated the preborn child as a person whenever it would be to his benefit. Based on authorities like Lord Coke and Blackstone, as well as landmark English cases, state high courts in the years leading up to 1868 declared that the preborn human being throughout pregnancy, quote, is a person, and hence under civil and common law, to all intents and purposes, a child, as much as if born. And that was Justice Shaw in Hall versus Hancock of the Massachusetts Supreme Judicial Court. One early decision, cited favorably by Dobbs actually, used language that bears a striking resemblance to the Equal Protection Clause to make this point. Quote, a child in the womb of the mother is under the protection of the law and possesses all the privileges of a living being. That's a Pennsylvania Supreme Court decision from 1819. Now, as Dobbs shows, the unborn child was considered a legal person across many bodies of law when it would be to his benefit. And at common law, abortion was unlawful at all stages of pregnancy, but was typically only criminally indictable as soon as a woman was quick with child, which was a phrase that had shifting meanings. Some courts understood this to be as soon as the child was alive, or quick. Other courts developed this to be understood as when the child's life could be detected by the mother, also known as quickening. Whatever those differences are, the rule was actually designed to protect life as soon as it could be shown to exist, not to exclude protection prior to that point. So even though every living embryo was a quick child, some courts use that quickening rule, right, first perceived fetal movement, as a useful evidentiary tool for determining whether the crime of abortion had actually occurred. Because, of course, there was great difficulty in proving the crime of abortion to show that the child was alive prior to quickening, right? And proving that the child was alive was often an essential element to proving that common law crime of abortion. In any event, the quickening distinction was actually largely discarded in statutory reforms leading up to the 14th Amendment's adoption, so that by 1866, Chief Justice Tenney of the Maine Supreme Court could accurately report that, quote, the quickening distinction has been abandoned by jurists in all countries where an enlightened jurisprudence exists in practice. So when the 14th Amendment was adopted in 1868, the states widely recognized preborn children as persons throughout pregnancy. Nearly all states had actually codified statutory criminal prohibitions against abortion, in addition to and supplementing, replacing, right, the common law. At least 28 jurisdictions labeled abortion as an offense against the person within their statutory classifications. And in 23 states and 6 territories, laws referred to the preborn individual as a child. In fact, the same Ohio legislature that ratified the 14th Amendment called abortion, quote, at any stage, nothing less than child murder. So strong language coming from the 1800s. I think it's clear that at the time of the amendment's adoption, nearly every state understood person to include prenatal life. But what did the drafters of the amendment themselves think? What was their expected application of the amendment? We'll get back to this in a minute, but I think that the framers expected the 14th Amendment's guarantee of equal protection to protect every member of the human species within U.S. jurisdiction. So the primary framer of the amendment, Representative John Bingham, believed that the amendment prohibited states from refusing, quote, any of the rights which pertain to common humanity. Senator Jacob Howard, who introduced it in the Senate, sponsored the amendment in the Senate, he declared that the amendment's purpose was, quote, to disable a state from depriving not merely a citizen of the United States, but any person, whoever he may be, of life, liberty, and property without due process. Even the lowest and most despised of the human race, he said, were guaranteed equal protection. Now, one mistaken approach to constitutional interpretation might claim that the preborn can't be protected by the 14th Amendment because Section 1 begins by declaring that, quote, all persons born or naturalized in the United States are citizens of the United States. So a lot of people come to me very concerned. They say, Josh, it says born right in the third word. How are you saying that the unborn child is a person when it says born right there? But what people aren't noticing is that if you're paying close attention, it's not defining the term person. It's defining U.S. citizenship. All persons born or naturalized, so you have to be a person, this broad and undefined class of persons, you have to be born or naturalized and subject to the jurisdiction of the United States in order to be a U.S. citizen. We're defining what citizenship is, right? And then the next clause, the privileges or immunities of citizenship, tells us what rights, what privileges those citizens have. But then the subject shifts when you get to the due process and equal protection clause. Suddenly, we're no longer talking about citizens, but rather any person, right? So the citizenship clause simply defines which persons are citizens, but does not define personhood or say that only citizens are persons. Indeed, it clearly acknowledges persons who are not citizens. Now, another mistaken approach to constitutional interpretation might claim that the 14th Amendment doesn't protect the unborn because it was most immediately designed to protect Black Americans from unequal legal treatment. But the amendment's framers deliberately chose that broad term persons to protect any human being who might be denied due process and equal protection. But I think some still wonder, if the 14th Amendment equally protects the unborn from homicide, why didn't the framers say so expressly in the ratification debates? Why didn't every single state immediately enact new statutory laws? Well, first, remember that the common law already prohibited all abortion, right? Even if it wasn't always criminally indictable. Second, congressional silence is completely unsurprising. As we've just seen, when the amendment was adopted, the states widely prohibited abortion. So unlike Black Americans, the law already protected unborn children and recognized them as persons. It's totally unsurprising that there would be legislative silence about the amendment's application to the unborn specifically. State laws denying equal protection to the unborn didn't come about until nearly a century later. Finally, I think that this argument from silence actually rests on some questionable premises that Congress only meant to achieve specific and immediate ends rather than create rules and applicable rules of decision, right? Originalist lawyers and judges today understand that what a text requires may be different from what the lawmaker foresees, right? Although, of course, the ratifiers here probably would have welcomed the interpretation had they foreseen it. As Justice Barrett just pointed out in her Rahimi concurrence, originalists have to distinguish between original meaning, which controls, and specific expectations about how a text would apply, which do not. Early applications of a constitutional rule can help illuminate its scope, she writes, but an interpreter must exercise care in considering them. So consider that when the 14th Amendment was adopted and for very long afterwards, illegitimate children were not equally protected under the laws of most states. For example, Louisiana defined the statutory term child to mean only legitimate children. The amendment's framers never discussed bastardy, right? Yet in 1968, Levy versus Louisiana applied the Equal Protection Clause to illegitimate children, explaining that they are, quote, not non-persons because they are humans, live, and have their being. So it'd be odd to interpret congressional silence about illegitimate children as evidence that such children were meant to be excluded from the amendment's protective ambit, or to conclude that the Supreme Court got it wrong when they looked at the meaning of person in the Equal Protection Clause. I think arguments from silence are often weak, and this is no exception. So finally, politics and prudence. What are the implications of this interpretation? Right? Some might say, even if everything you've said is true, it's not prudent. I think that detractors make much of the view that no Supreme Court justice has ever adopted this view, and they argue that the strategy would be imprudent for that reason. But numerous justices have acknowledged that if the unborn child is a person, then they would necessarily be outlawed abortion nationwide. Tripping over my words there. But even Justice Blackmun acknowledged that in Roe v. Wade. More importantly, the meaning of the constitutional text isn't determined by the agreement of the justices, and it certainly wouldn't be the first time that a constitutional application has slept unnoticed by its robed interpreters. Until District of Columbia versus Heller, no justice over the course of 2 centuries had ever expressly written that the Second Amendment protected an individual right to bear arms, yet an originalist court held so in 2008. Of course, the courts themselves were never intended to be the primary enforcers of the 14th Amendment. So what would a legal strategy look like to advance equal protection for the unborn? I think rather than fixating solely on the judiciary, a long-term pro-life 14th Amendment strategy would also focus on state as well as congressional and executive action at the federal level. Right? The most natural and immediate avenue for advancing equal protection would be through Congress. Section 5 gives Congress an enumerated power to, quote, enforce by appropriate legislation the guarantees in Section 1. Right? It's a specifically enumerated power. Dobbs didn't determine how a future Supreme Court might view national pro-life legislation enacted under Section 5, and even Justice Kavanaugh acknowledged twice in his concurrence that future abortion policy may be addressed in the states or Congress. Second, every Republican Party platform from 1984 until this year supported, quote, legislation to make clear that the 14th Amendment's protections apply to children before birth. But if the unborn are not persons within the meaning of Section 1, I believe Congress would lack power to enact national life protective legislation under Section 5, such as a Life at Conception Act, a Heartbeat Act, or a 15-week bill. Looking to the executive, the next pro-life president also has a role to play. In a 1988 proclamation, President Ronald Reagan called for, quote, the personhood of the unborn to be declared and defended throughout the land under the 14th Amendment. The next pro-life president has a constitutional duty to, quote, take care that the laws be faithfully executed, right? It's an Article 2 duty. And I think that that includes, perhaps, issuing an executive order to ensure that unborn children are treated as persons within each federal branch, each department and agency under the executive's authority. If the unborn, however, are not persons within the meaning of Section 1, then a president would lack the authority to issue such an order. Now, in the years before Roe, there was a lot of discussion and dissension about the path forward, and I think that the same is true of our movement now after Dobbs. But it would be unfortunate if at this early hour, advocates for the unborn discarded the use of one of their most powerful legal tools. If the unborn are human beings, as they undeniably are, then we must have the courage of our convictions to seek their full acknowledgement as persons under the Constitution. As we seek to build on our victory in Dobbs, we would do well to remember the words of one of Justice Robert Jackson's greatest opinions, in which he wrote, "One's right to life may not be submitted to a vote. It depends on the outcome of no elections." The foundational error of Roe was not that it denied and short-circuited the democratic process, but rather that it denied equal constitutional personhood to the weakest and most vulnerable among us. Thank you.
Thank you, Mr. Craddock. Now we get to hear from Mr. Whelan. You have 20 minutes as well and the time to respond to Josh's comments.
Thank you very much, Olivia, and thank you, Josh. It's a real pleasure to be here. I'm in the odd situation of being at least ostensibly, the less pro-life panelist on a panel, something that's never happened to me before in my life. I have spent much of my adult life working for the pro-life cause, working to overturn Roe, working for the robust protection of the unborn. Imagine this. Your home is burning down. Your kids are trapped inside. What do? Do you act quickly to save as many of them as possible? Or do you leave the scene and go work on developing an ingenious new method of building materials so that some house in the future might never burn down? We are at a crisis point for the pro-life movement. The idea that the next logical step is to go to the courts to set forth an argument that no justice has ever bought and that no majority of the court ever will buy is, I think, ludicrous. Now, I have a great deal of respect for my colleague and friend, Josh Craddock. I think that his legal argument is much stronger than I anticipated when I first encountered it a few years ago. I think it passes the threshold of plausible. I think it is well short of compelling. But again, to play legal realist, there is no chance that a court will ever adopt it. And if, say, abracadabra, the court adopted it today, what would happen? You would have, faster than you know it, a constitutional amendment that would restore abortion policy to the states. What we need to do above all, in the path to that, ultimately sometime there might be a ruling such as Josh anticipates, we need to build a culture of life. We need to work throughout this country, state after state, to salvage what we can of legal protections for the unborn, to build more, not to delude ourselves that there's some sort of legal argument that's going to save us. It is not going to happen. So let me start by explaining why I am not persuaded by Josh's argument. Again, I'm not saying that I'm going to demonstrate that it's flatly wrong, but there are reasons beyond those, some of which, some of them Josh has referred to, but others that he hasn't, that I think are problematic. Let's start with the text of the Constitution, which refers some 30 times to the word person, including in the text that preceded the 14th Amendment. Now, in at least one of those instances, the word clearly is in the context of counting. How many persons are there out there? And of course, that's also true in a provision of the 14th Amendment itself, Section 2, that calls for representatives to be apportioned among the states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. Now, this text could have said, excluding those not yet born. There's no indication that anyone went around trying to count persons who weren't yet, who are still in utero. There's no suggestion that some administrator thought there's a legal responsibility to do so, but used convenience as a reason not to. Now, I'm not presenting this as a decisive argument. I think it, at the beginning, just raises doubts as a matter of text. Now, let me look at the missing evidence, which I think is far more problematic than Josh indicates. So as I understand the historical account, by the end of 1868, the 14th Amendment, of course, was ratified in the midst of 1868, some 27 of the 37 states then in the Union had enacted statutes against abortion that superseded the common law prohibition that applied from quickening. And these statutes applied before quickening, from conception, I gather. Under Josh's theory, that would mean that the Equal Protection Clause obligated at least 10 states to enact statutes that generally prohibited abortion from conception. And I don't think it's enough to say, oh, well, these were still unlawful under the common law, because you need to provide equal protection. You need to, under his theory, provide the same guarantee for these lives that you provide for people walking around. And it's not enough to say, it's unlawful for you to kill them, but we're not going to punish you. Now, if the Equal Protection Clause meant what Josh says it meant, wouldn't we expect some evidence somewhere that some legislators in those 10 states recognize that the 14th Amendment would obligate them to enact such statutes? Wouldn't you think that someone working to enact a pro-life law would say, not only is this good policy, but we're required to under this 14th Amendment that's just been enacted? Zero evidence that anyone has ever identified of such an argument being made anywhere. Wouldn't we have expected supporters of statutes against abortion to invoke the Equal Protection Clause? Also, let me add, in the debates over the 14th Amendment, there is not a single reference that's ever been called to my attention that has anything to do with abortion. As Robert Bork wrote in a debate on the same topic 2 decades ago, it passes belief that nobody would have said so or raised the question for discussion, but the records are bare of any such question or discussion. Now, if you look at the trend of state abortion enactments that preceded the ratification of the 14th Amendment, they continued at a leisurely pace in the years after. There's no sense, aha, now we have a new obligation, let's get going and make sure our statutes comply with the 14th Amendment. So the fact that the trend was the same suggests that the 14th Amendment had no effect on the post-ratification enactments. Now, on the topic of original expected applications, this gets into originalist methodology. I'm not sure we can get too much into the weeds here, but there's zero evidence of original expected applications. Again, zero evidence that any ratifier had an expectation that the 14th Amendment would apply with respect to abortion. Now, Josh, in a previous debate with me, has said that I'm applying a higher standard of proof here than we apply in the context of school segregation. So let me just respond to that right now by saying no one disputes that the primary purpose of the 14th Amendment was to put an end to various forms of state-sponsored racial discrimination. By contrast, Josh doesn't contend that the drafters or ratifiers of the 14th Amendment intended it to have any effect on abortion. Then let's get to inadministrability. Now, the argument I'm about to make could play out in different ways. You could say the fact that the Supreme Court couldn't possibly administer such a scheme shows that it's folly to pursue it, which I think is true. You could say the fact that the Supreme Court would be playing this impossible role also reflects that the 14th Amendment shouldn't be understood to impose such a role, which I think is also true. How does the Supreme Court have the institutional capacity to impose such a system? The court ordinarily supervises state laws by deciding whether or not they violate the Constitution and by relying on the judicial hierarchy to implement its assessments of which laws are unenforceable. But under Josh's theory, it would seem that the court would be in some way requiring the states to affirmatively enact criminal laws prohibiting abortion. What would the court do? What would it be able to do if the states simply refused? Again, imagine that the court made such a ruling today. What do you think legislators in New York would do? Oh, the Supreme Court has spoken. Now we're going to enact laws against abortion. Are you kidding? Never happen. And further, when you understand that the 14th Amendment was adopted and ratified in large part to counter the judicial excesses of Dred Scott, why would you imagine that this amendment would be giving the courts such power here? On administrability, let me also add in the question, what would this mean for IVF embryos? Is the Supreme Court going to concoct a regime with the, hundreds of thousands of IVF embryos out there that states need to develop some sort of adoption program to make sure these embryos don't remain in suspended animation forever? Would the Supreme Court be dictating what IVF policy is going forward? Now, I won't hide from you that I am someone who would prefer that IVF were not a practice in this country, but it clearly is, and I simply don't see how the court could begin to manage that. Now, on Congress's Section 5 authority, here I'm actually much more sympathetic to Josh's argument. The only problem is there's Supreme Court precedent that stands clearly in the way. That is, I believe that Section 5 of the 14th Amendment actually confers a lot of power on Congress to define what vague terms in the 14th Amendment mean, and that there's been a power grab by the Supreme Court, by conservatives and liberal justices over the years, to say, no, it's our job to say what it means, and your Section 5 power is extremely limited. That was a holding in a case called the City of Bernie v. Flores in 1997, which held that Congress lacked the authority to impose the Religious Freedom Restoration Act obligations against the states. So again, I am sympathetic to an argument that the power ought to be much broader, but that's not where we are. Let me then turn to what I will gently call the political folly of this approach. Lincoln famously said, in words that I think still ring true today, "In this age, in this country, public sentiment is everything. With it, nothing can fail. Against it, nothing can succeed. Whoever molds public sentiment goes deeper than he who enacts statutes or pronounces judicial decisions." Since Dobbs, the pro-life movement has done a terrible job, an awful job of trying to mold public sentiment. We've had loss after loss for a whole variety of reasons we can get into, and actually the worse things get, the more some people seem inclined to what I'll call a desperation argument, a Hail Mary pass, I suppose, to rely on constitutional personhood. What we need to do is going to take patience, it's going to be difficult, we're going to have lots of losses. What we need to do is get serious about pursuing a strategy of prudent incrementalism. What do I mean by that? I don't mean some sort of grand compromise. I don't mean giving up on this fight. I do mean, though, that we need to start winning legislatively. We need to recognize that when the fight is on the hard cases, and I'm not using scare quotes, there are cases that are genuinely much harder than others, we are going to lose. So if you are, pressing your legislator not to, say, have a rape exception in a pro-life law, you are asking to lose. That doesn't mean that I believe that the life of an unborn child conceived in rape is worth less than anyone else's life, and it's certainly a life I would like to protect. It's a life that we ought to find other ways, if we can't protect it in law, of making sure that adoption services are made available to the mother, providing other ways, making sure, say, the rapist is caught, other rapists are deterred, say, by DNA testing of fetal remains, or all sorts of other things one can think about doing. But if we go in saying, no, we're absolutists, we feel very good about ourselves, we're not going to recognize at all where the public is, we're not going to develop a strategy that actually wins anything, we're just going to get wiped out, and then we're going to hope that somehow, in a culture that becomes more and more pro-abortion every year, we're going to have 5 justices sometime adopt a position that no justice ever has. To me, that's fantasy, a very dangerous fantasy, and it's one that I would discourage you from indulging. Happy to leave it there. Thank you.
Thank you, Mr. Whelan. Josh, do you have some response to that?
Let's see, is this working now? Yeah, sure. Well, first of all, thank you for raising these important counterpoints. I think that some of them are worth considering. The first one, I think that, which is probably, I think, Ed's strongest argument, is the textual argument from Section 2 of the 14th Amendment, which discusses enumeration, right, census taking. And I think that there's 2 points in response to this. I think first, Section 1's use of person has from the 1880s been interpreted to be broader than the use of person in Section 2, right? Corporations, for example, are persons within Section 1, but not within Section 2. Second, I think more importantly, as a matter of custom and convention, the decision of whether to include unborn children rested on practical difficulties of counting such children, particularly back in the 1800s, right? Back then, it would have been quite infeasible to enumerate unborn children unless through, grossly intrusive personal examination or questions challenging to modesty. So I think that as a matter of custom, convention, and feasibility, it's not surprising that unborn children were not historically counted for the purposes of apportionment, and I don't think there's anything offensive to equal protection in that fact. I think second, on the dog that didn't bark argument, right, the argument from silence. I don't think the states would have had any obligation to pass additional statutory law because, as I said, at common law, abortion was already criminal at all stages, even if it was criminally indictable only after quickening, right? This basically means that abortion prior to quickening would have been an inchoate felony for purposes of the felony murder rule, right? I also don't think there was any abrogation of fetal rights until nearly a century later, so it's not surprising that we didn't hear them thinking and talking about it, right? I'll be the first to admit that wasn't what was on their mind subjectively at the time, but it is in the text and in the original public meaning of what they enacted. On the applications, I think that this shows that the expected applications were that the Equal Protection Clause would apply to all persons, but we know that many thought at the time that it wouldn't apply and said at the time that the Equal Protection Clause would not affect school segregation. So to that extent, I think we have a stronger argument here, where at least it's neutral, than Brown did in saying that school segregation was against the Equal Protection Clause, and yet Professor Michael McConnell has argued persuasively that on an originalist framework, Brown is justifiable, notwithstanding those comments against school desegregation. On the point about the duty to legislate, I agree with my friend Ed, there would be no duty on the part of states to legislate, but it would mean, a personhood ruling would mean that discriminatory exceptions to homicide laws that would otherwise be applicable would be invalid or null. A state could not pass a law, for example, I think we would all agree to say that murder is committing homicide with malice aforethought unless the victim is Black or left-handed or of Croatian descent, right? Those would all be obvious equal protection violations, and the remedy is not to, say, pass a new statute, but to strike or sever the offending language, the offending exception from the statute so that the general rule applies. On Section 5, I think we have a lot of agreement in some ways. I agree that Section 5 enforcement, I think the Supreme Court has taken a too narrow view there, especially in its Section 5 holding in Morrison. But I think that the problem for Ed on this point is that Congress can't pass life-protective legislation under Section 5 unless the unborn child is a person within the original meaning. Congress doesn't have the power to enforce something that isn't within the original meaning of the text. And I want to conclude with a point on practicality and kind of the point of that Ed raised about the prudence. You know, it took us 50 years to overturn Roe v. Wade. I don't have any illusions that achieving or sustaining a personhood decision or ruling would be a short process. But if we're going to be fighting for the next 50 years, I want our aim to be true. The target that we're aiming for should be equal protection. And speaking of Lincoln, the quote that Ed read is great. Of course, we need public sentiment is everything, but that doesn't mean follow public sentiment. Lincoln says the one who molds public sentiment is better than one who passes statutes. So what sentiment should we be molding? That unborn children are the same as you and I, that they are persons and that they are entitled to equal protection. That is the sentiment that we must be molding. And I think that speaking of Lincoln, his debates with Stephen Douglas provide a helpful framing for the situation where we find ourselves in now, where Stephen Douglas was saying popular sovereignty, each state gets to decide for itself. Lincoln reminds us that the constitutional majority's legitimacy is grounded in nothing other than the equal natural rights of the persons that constitute it, so that a majority cannot deny or disparage the rights to the minority without vitiating its own legitimacy. Thank you.
Very, very briefly, as I'm eager to get to your questions, I think Josh and I then agree on the need to mold public sentiment. I guess we disagree on what is an effective way of going about that. On corporations as persons, the Supreme Court, in recognizing corporations as persons for one part of the clause and not another, recognized it to be sort of double counting if you recognize them as persons in the census section, since corporations are associations of people. That logic doesn't extend to unborn children. And then I just have to confess that I don't understand the distinction that Josh draws between criminally indictable and criminal, or more precisely, to the extent that I understand it, I think that it is a distinction that ought to violate the Equal Protection Clause. In other words, I don't think that you can say that, you could make the killing of all those 3 years old and younger criminal, but not criminally indictable. But if somehow they survive the attempted killing and later on die after 3, then it's a criminal act that can be indicted, which I think, perhaps I'm mistaken, is a rough analogy to the argument made in the abortion context. I think that Section 5 authority is much broader than Josh indicates. I don't think now here we're sort of switching sides, and he's arguing that Section 5 authority is narrower than I'm arguing that it is. So let me just be clear. I believe that for a court to override a democratic enactment, a certain level of certainty, compelling argument is made to show that democratic enactment violates the Constitution. I believe that for Congress, there's a much lower standard that applies, and that Josh's plausible argument would be enough for Congress to say, okay, we are going to treat the unborn as persons under Section 1 of the 14th Amendment. I believe further that Congress would have authority to outlaw abortion under Section 5 based on concerns over what abortion does to women, indisputably persons under Section 1. So again, I think it's odd that we sort of switched a little bit on that. In any event, that's all I have for now.
Great, thank you both. We're going to enter our question and answer period, but I actually have a question for you, Ed, before we get going. I'm curious, you started with an analogy of the house on fire and that your focus has to be rescuing your kids out of the house or, preventing house fires in the future by developing a wood or building material that can't be burned. But I would suggest that that's not exactly the analogy that we have here, because there's a diversity of movement in the pro-life movement, a diversity of focus, and what we are trying to achieve, maybe some legislative, some at the courts, and also at the hearts and mind, the public sentiment. But I'm curious how you would compare the pro-life movement to, say, the Civil War, the view of slavery and the public sentiment that was there, and then also the civil rights movement.
Well, that's a big, big question. You're certainly right that there's a diversity of approaches in the pro-life movement, and that's one of the reasons why we're getting hammered, because there is not any sort of consensus about figuring out what is prudent incrementalism. Indeed, a lot of people reject the whole notion of the legitimacy of prudent incrementalism. I think there are lots of analogies that can be drawn to the fight against slavery. I don't know that these analogies really help much here. I mean, look, we all, those of us who understand the deep injustice of abortion find it very difficult to legislate in a way that will allow this. That's not easy to do. You don't want to do that. We're all, temperamentally William Lloyd Garrison, who did not succeed. So look, you had a terrible Civil War. You had the adoption of the 13th, 14th, and 15th Amendments. You then had a failed effort at Reconstruction, and it took a long, long time to really begin to ensure the rights of African Americans and other racial minorities. We need to be ready to be in it for the long haul. But again, I'm really frustrated, that may be too mild a word, by how the pro-life movement does not seem to have undertaken the effort to change minds and change hearts since Dobbs. It has instead allowed the debate to focus on the hard cases, the debate's all been on the other side's terrain, and we're just getting hammered. And politicians are followers, not leaders. It's one thing you need to understand. You say, oh, if only we had braver politicians. We're not gonna have brave politicians. Okay, you have to make the path easy for a politician. So look, what Donald Trump did, his betrayal of the pro-life cause, that was a path of least resistance. It's not surprising. And it's in part a product of the fact that the pro-life movement was not ready for Dobbs, which is an amazing thing to say. But this movement built up over 50 years around Roe, and I think became sort of parasitic on Roe, to the point that you even had a major pro-life group, the National Right to Life Committee, or once a major pro-life group, submitted an amicus brief in Dobbs, an atrocious amicus brief. This case is teed up for the court to overturn Dobbs. Scott Stewart has already submitted his brief saying overturn Roe, And the National Right to Life Council says, you don't need to overturn Roe in this case. You don't even need to decide whether the Mississippi 15-week law is constitutional. You just need to come up with some new fuzzy standard and send it back to the same bad panel that ruled against you the first time around. How can that happen? How could a group do that? Well, the group is built up around Roe, and even after you had the leak in whatever it was, early April, in Dobbs, where was where were the folks getting together saying, okay, we've got to be ready, we have to have legislation ready to go? There's another major pro-life group that has never had, whose task you think is to come up with model legislation in the states. It's never put forth certainly had back then a model pro-life bill. Instead, it has all sorts of things on regulating hospital corridors. Great. That's what you do in the world of Roe. You don't do that. You don't do that after Roe. So, I think we need to. I just hope everyone in this room who is pro-life will recognize what an awful situation we are in, and how we need to hold some ground if we're ever going to get to the world that Josh and I both want to see.
Right. Yeah, I absolutely agree. We need to not just hold ground, but gain ground. And I think the pro-abortion movement has done a lot of the work that they needed to do over the years, because they're the ones educating the people and they're the ones winning sentiment. So we definitely need to step in and take that ground back. Josh, I think this is going to apply mostly to you, but Ed, you may have some comments too regarding the practical and political implications if we did acknowledge the personhood of the unborn under the 14th Amendment. This question is, how does this discussion around abortion and when a child is proven to be alive apply to frozen embryos?
Well, is this on? Hello? Still working? Might have run out of battery. I don't know.
Here, try this.
You want to take mine?
So it's a great question, and I think it goes to one of the points that Ed raised earlier about IVF. I mean, I think that Ed and I actually agree. I mean, embryos created through IVF are human beings. They are human embryos, right? We agree on that. On my view, I would say that also they would be entitled to certain legal and constitutional protections. So I know Ed also agrees that destroying human embryos is wrong, destroying frozen human embryos through IVF. And so I think that we have a broad agreement there. I do think that it would have the 14th Amendment ruling would have implications for state laws allowing the creation, indefinite retention, and destruction of human embryos. And I think that those are serious ethical concerns that we should take seriously.
Did you have any comments?
No.
Okay. Can everyone hear me?
Sorry. Give you your mic back.
Okay, I'll swap it out with you. Okay, the second question is also, I think, maybe for you, Josh. What would Blackstone say about the Dobbs opinion? Would he have done anything differently?
This is like that Alito question about whether the constable could fit in the back of the buggy, I think. No, I think Blackstone, the principle from Blackstone is that if human life can be shown to exist, then legal personhood existed also. I don't think that, but I think that the decision is perfectly defensible on its own terms, right? There are doctrines that party presentment, right? If the party doesn't present the argument, the court's not going to opine on it. If it's not within the question presented, the court's not going to opine on it. So whether what Blackstone might substantively do outside the context of those doctrines, I would like to say he'd agree with me. But I don't think that's any knock on the Dobbs opinion, which is perfectly sound, answering the question presented.
Okay, this is in the same vein of that question, and it may be for both of you, but why do you argue that IVF is anti-life? I think, Ed, that might be a reference to something.
Why do I argue that what?
That IVF is anti-life. Would you say that to someone who is an IVF baby?
Well, look, I would. Obviously, this is a delicate topic, especially for IVF babies, just as I'm sure that, look, let's first establish the elementary proposition that the morality or immorality of the means by which a human being is conceived does not detract from that person's human dignity. We don't say, and I'm not saying that rape is like IVF, but here's the principle. We don't say that if someone is conceived in rape, that person is less human or less deserving of dignity. So there's nothing about being an IVF baby that makes you any less human, any less deserving of dignity. I did not specifically say that IVF is anti-life, though I'm happy, I think, to defend that proposition at several different levels. One is that the way IVF has been practiced in this country for years and years results in profligate destruction of unused embryos, storage for decades of these frozen embryos. It's, I think, a galling situation that folks tend to just hide. There's never been any real discussion of that. No one ever, thinks of trying to regulate it. Now, there's a separate matter, and maybe I wouldn't apply the term anti-life to this, but I think that IVF also results in the commodification, embodies the commodification of babies. It's, I think, impossible to de-link from a whole host of other practices, surrogacy, for example, that I believe, are deeply demeaning, not of the individual who results from that, but for the folks who take part in it. At bottom, I'll acknowledge that I subscribe to the Catholic understanding of marriage and of procreation. And I do not believe that these artificial means of reproduction are legitimate. But that doesn't mean that statement doesn't mean that I would use the term anti-life for every single one of them.
Thank you.
And I agree with, as a Protestant, I agree with everything Ed just said. I just want to add, in terms of regulation in the United States, IVF is much less regulated than other countries where, for example, in Australia and New Zealand, there are regulations or ethical guidance that says you should only fertilize a single embryo and transfer, which reduces the problem of creating multiple embryos who are then either put into frozen storage indefinitely or intentionally destroyed.
Thank you. That's a great point. This may be to both of you. Today, much of the public's opposition to the 14th Amendment's protection for the unborn seems to be based on biological or medical beliefs that the unborn are not biologically the same as the rest of the persons protected by the amendment. How does the pro-life movement overcome this perception?
Well, I guess I'll question the premise for starters, that I'm not sure that one person in 100 has given any thought to the constitutional personhood argument. But when one understands, say, the public support for abortion, there's a cohort of folks, I've started to encounter them on Twitter, who deny the basic reality of the fact that an unborn human being is a living member of the species Homo sapiens. There's a sort of flat world embryology that prevails, including among very intelligent people. Now, I don't know how much of that is just motivated reasoning, but then you have other people who will say, and this I think captures the muddled middle that is currently decisive in legislative debates, will say, I don't care whether the unborn human, whether the embryo or the fetus, of course I mean the human embryo, the human fetus, these are stages of mammalian development. We don't, there's not some sort of separate species called a fetus, so sometimes you think there is, but they would say, I don't care. I would prefer, somebody say, I prefer that the baby not be killed, but I'm not going to support laws that prevent that, at least in these different hard cases, or at least, before X weeks. So you're not dealing with, look, there's an understandable ambivalence. I don't mean to ridicule the seeming incoherence of the position. It's one that I think folks are driven to for lots of different reasons. But I think that the denial of biological reality is only a small part. I think we're seeing more and more as just a small part of the support for abortion.
Do you have anything to add?
I agree.
Okay. We received a lot of questions. Thank you very much. I don't know that I'm going to be able to get to all of them, so I'm trying to be selective and encompassing of your questions. But I think all of you in the audience should be interested in this one. Why should we, as students, seek to choose a side in this debate instead of supporting efforts to both incremental change and a personhood constitutional amendment?
Well, first, I don't think there's any conflict between supporting incremental efforts and also as long as those incremental efforts are ultimately in the service of the goal of ensuring equal protection eventually, right? There's no shame in saying, yeah, this is the goal I want. I want to ensure equal protection. What I can get right now is a heartbeat law or whatever it is, right? I don't think there's any shame in that. You should advocate for it. But as students, I think your scholarship is incredibly helpful for your student notes, for example. Right now, there are a bunch of different states that have state constitutional questions about whether their existing state constitutions guarantee a right to abortion. I've been making an argument from the 14th Amendment, but you could do your state constitution. What was the original meaning of your state's constitutional guarantee, many of them have, of equal protection, or of the rights of persons, or of the personal security? that would be a great research topic. Look up what your state constitution, the originalist interpretation of your state constitution is, to help arm and equip the advocates who are defending their existing state constitutions right now, right? There is a great example of this was Florida just recently. In addition to the amendment that they're trying to add to the Florida state constitution, there was litigation over the existing law under the Florida Constitution and whether their right to privacy guaranteed an abortion. Your student notes and your legal research can help equip the advocates who are going to go in and defend those state constitutions. So I think that, picking a side, you don't have to pick a side. I hope that whatever incremental work you do is ultimately in the service of the goal of equal protection. But I think that what you can do right now as students is to weigh in to help add to the scholarship and to help equip advocates.
Very briefly, I would say that in theory, you don't need to pick a side, but in reality, you might need to. Resources are scarce. I think there's something about the personhood argument that leads people to oppose incrementalism, leads them to think that here they have this silver bullet that makes incrementalism unnecessary. So if you can avoid that temptation, then I think it's fine to try to do both. But again, I would say that given in a world of limited resources where the other side has 1,000,000 times the resources that we do, I think every effort should be made to try to even hold the legislative ground that we have and to work to change the public's view of abortion.
Thank you. To both of your points, I think as students, you are generally overwhelmed by law school. Having been there not too long ago, although it was longer than I want to remember. But remember that you're gifted and talented in certain areas, and everybody has a calling, and I think everybody has a calling to this fight, and you just need to hone in on what your calling is and what your talents are and utilize those, and then come alongside of those others who may be doing different work, but see how you can support and complement one another.
Could I just add one more comment on the incrementalism point?
Sure.
So one thing that I think on the incrementalism point, people might say, well, isn't it inconsistent to advocate a gestational age ban, for example, and also advocate for personhood? But I think that equal protection, for example, say a state were to pass a heartbeat law that is under-inclusive of the equal protection guarantee. I think the Supreme Court has long recognized, such as in Minnesota v. Cloverleaf Creamery, that even in that equal protection context, a legislature may implement its program step by step, adopting regulations that only partially ameliorate a perceived evil and deferring complete elimination of the evil to future regulations. So I think that's permissible under equal protection jurisprudence. And even if it were not, if the Supreme Court were presented with this and said, hey, this gestational age ban is inconsistent with the equal protection clause, after a certain time, right, if the state is not taking step-by-step measures, then the remedy would not be to level down protection and strike down the law allowing all abortion, but to level up protection, right, to remedy the equal protection failure to ensure that all unborn children are guaranteed equal protection.
Great, thank you. And on that, we have reached our time limit, so I'm going to say thank you to both of our speakers, and we really appreciate the time and your comments.